So my name is Elaine Carey. I'm Dean of the College of Humanities, Education, and Social Sciences at Purdue University Northwest. I'm also a historian of crime, so I'm really pleased to be welcoming you to the Center for Visual and Performing Arts for this important forum, Wrongful Conviction, Righting a Wrong. And the purpose of the forum is to address how an innocent person can be wrongfully convicted and some of the work that is happening to really reform the criminal justice system. So before I introduce our panel and the event, I would like to thank a couple of people. Nikki Jackson, who is also moderating this panel, brought the idea to the attention of the college and her department, and so I would really like to thank her. I also would like to recognize the Department of Behavioral Sciences at Purdue University Northwest and the chair, Paul McGrath. Rachel Pollack, who is the Chess Webs and Events Coordinator, has worked tirelessly on this event as every other event, and I also would like to thank her. As well as Liz Rodriguez, Eileen Long, Sonia Domovsky, and Kirsten Markusik, who all work in the Chess office. Here at the Center for Visual and Performing Arts, I would like to recognize and thank Ann Davis, head of production, Richard Freeman, who is the general manager, and also Christine Carbonari from catering, as well as Chef Trauma. So we are here in the center, so please feel free as you walk in. You can also check out forthcoming shows, the art, and as well as the gift shop. There's lots to see here at the center. Before I begin the introductions, I would like to mention some basic housekeeping items. We are recording the forum, and that recording will be available on YouTube, and we will also circulate that through social media. But due to continued litigation, I ask that you refrain from recording or photographing the panelists during the forum. This is also basic best practices in social science research methodology, in which a researcher always asks for permission and gains consent prior to recording or photographing anybody. So I ask you to do the same. This year marks the 25th anniversary of the Innocence Project, which was founded in 1992 by Peter Neufeld and Barry Schleck at the Cardozo School of Law in my home city of New York. The project seeks to exonerate the wrongfully convicted through DNA testing and reforms of the criminal justice system to prevent future injustice. And their work has exonerated 362 people, 20 from death row, and many who had served an average of 14 years in prison prior to release. Today we are joined by attorneys and exonerees. And initially we will watch a film, followed by discussion by the attorneys and also Beth from the Innocence Project and representatives from After Innocence. That will be followed by lunch and then a discussion with the exonerees. As a historian, I like to think about law as an applied history degree because it is based on precedents and seeks to understand the past in order to change the present. I also argue that exonerees too embrace historical methodology to understand their past in the criminal justice system and to actually change the present for the better. So it is my pleasure to introduce our panelists. Nikki Jackson is an associate professor of criminal justice at PNW, and currently she has been working with legislators in the state of Indiana on a compensation bill. Beth Powers, and also if everyone would raise their hand as I'm calling her name, because we're not sitting in order. We're allowing people to sit where they like, which is important. Beth Powers is the state policy advocate for the Innocence Project, and she leads state-level campaigns to enact policies and laws that benefit wrongfully convicted individuals and prevent future injustices. John Eldon is an attorney in Oakland, California, and he is the founder and director of After Innocence. And his work has been profiled in many publications, and recently in the Marshall Project, Berkeley Law School, California Magazine, Huffington Post, and Time Magazine. Fran Watson is a clinical professor of law at the Indiana University Robert H. McKinney School of Law at IUPUI, where she directs the Wrongful Convictions Clinic. Bernard Carter has served as the Lake County prosecutor, and he formerly served as Lake County Superior Judge. And he has also been a board member of the Association of Indiana Prosecuting Attorneys, and he's also sits on the Chess Advisory Board. Christine Bunch. Ms. Bunch is a former client of the Center on Wrongful Convictions. She spent 17 years behind bars in Indiana after being wrongfully convicted of setting a fire that claimed the life of her 3-year-old son in 1995. Willie Timmy Donald. In 1992, there were 6 armed robberies in Gary, Indiana's Glen Park neighborhood, and one of them ended with the murder of 30-year-old Bernat Jimenez, who was gunned down when he fought back. Mr. Donald was arrested and convicted of the robbery and murder that he did not commit, and he spent 24 years of a 60-year sentence before he was released. Roosevelt Glenn. Mr. Glenn received a 36-year sentence in prison for the rape which occurred in Hammond, Indiana, and he, along with another man, were arrested and convicted. Police believed that these men were involved in a recent bump and rob cases. He was exonerated after spending 17 years in prison. Mr. Eldon will introduce the film that we will watch, but prior to do that, please join me in welcoming our guest today. John, I'd like to turn it over to you.
Okay, thank you so much. Can everyone hear me? Am I, yeah? Good morning. It's great to be here, and wonderful to be asked to introduce After Innocence. It's a film that moved me tremendously when I saw it for the first time back in 2005. And the organization that I started a few years ago is a nonprofit, and it's named After Innocence in part, a large part, inspired by the film. And it's a feature-length documentary. We're going to see a clip today of just a part of it. But I want to just frame it for you a little bit. It came out, I believe, 2004, 2005. It was about that time that we were just really beginning as an innocence movement to come to grips more than before with the idea that this process of looking at our justice system, getting people out of prison who did not commit the crimes for which they were convicted, reforming laws to make it more likely that those things would come to light, those problems, those errors would come to light in the post-conviction sense, and also in reforming the system to prevent wrongful convictions at the front end. We'll be talking, I think, a little bit more about that further on. That was pretty well understood, but as we got more and more exonerees coming out of prison across the country, it became apparent that the work wasn't over and their journey was far from over. And so this is a film that focuses on After Innocence, what happens after people get out. And the way the film is structured is I think it's 6 or 7 total stories, different exonerees. And you meet them in the film in sort of episodes, and it kind of pops around. And one story, though, actually is an exoneration story that flows through the film. And that's the one you're about to see the clips from. And so at the beginning of the film, You meet this individual while he's still in prison. Sorry to give it away, but spoiler alert, he gets out. But you follow the process, and this is very helpful framing to sort of help think about something we're going to talk about today, which is what happens to them afterwards, and what we can do to make their road better in rebuilding life after wrongful conviction. So I'm going to start the video, and
October 17th, 1994. Dear Mr. Newfield, my name is Wilton Dedge, and I am very interested in the organization, the Innocent Project. I don't know where else to turn. I've tried everything I could to prove my innocence when all this first started. When I found out that the police were looking for me, I turned myself in, knowing that it was all a mistake and that it would be straightened out. I could write a number of pages telling you how outlandish the case is, but I know that you are very busy, so I'll close for now. I thank you in advance for your time and any help you can give. Sincerely, Wilton Dedge. I was locked up when I was 20 years old, just turned 20 years old, and I'm 42 now, so I've been in a little over 22 years. I was convicted for rape and sentenced to 2 life sentences. I really don't understand how I was even brought to court, much less convicted.
According to the description the girl gave, their assailant was over 6 foot tall, 180 to 200 pounds, long blonde hair and receding hairline, which the only thing that matches him is long blonde hair. Anyone that's had children, you've got a gut feeling whether they're telling you the truth or telling you a lie. And whichever way it is, it usually comes out the way your gut feeling was. And my gut feeling has always been that Wilton was telling me the truth about this. There's just no way I believe he's guilty of what he's been accused of.
About 6.5 years ago, Barry Scheck called, and he said that they had 3 cases in Florida, and would I be willing to do them? And he would positively guarantee that I would never get paid, and in fact, that it would cost me money to do this, but that if I did a good job, he would send me more cases where I wouldn't get paid, and it would cost me money to do it. So, how do you turn down an offer like that?
They had 2 hairs and a semen sample from the scene. The first test, the semen sample, was inconclusive. So we had the 2 hairs found that they used against me in trial and had the DNA testing done on it, and it proved beyond a doubt that it wasn't mine. Judge Silvernail granted the admittance of DNA testing and said that had I had it, I probably would have been acquitted. And the district attorney filed an appeal trying to get the judge's decision overturned, saying that even though it proves it's not mine, that I didn't file properly.
The presiding judge of that court asked the Assistant Attorney General, I want to make sure I understand your position. If this man is entirely innocent, is it still your position that he's entitled to no relief at all? And she said, yes, that's our position. And his jaw fell open.
Basically, I proved my innocence too soon, is what they're saying.
Wilton Dedge is the case that poses the question, does innocence matter in Florida? You have to go back to the days of Jim Crow to find an instance where the state of Florida has been as cruel as it has been in the case of a man who has been demonstrably innocent for 3 years, never mind incarcerated for 22, demonstrably innocent for 3, and is still behind bars.
They wouldn't give us access to the evidence. They wouldn't permit the DNA testing. Even when we got DNA testing that was exculpatory of Dedge, they didn't want the judges to look at it. They didn't care whether he was innocent. They were more interested in covering themselves against the possibility they made a grievous mistake. The so-called finality of the system was more important than getting an innocent person out of jail and finding the person who really committed the crime.
The Innocent Project wrote me back asking for more information. Once they read through the records, they couldn't believe I was convicted. And they've been supportive the whole time.
Welcome. It's really great that you're all here. We started out as a small clinic at a law school trying to free people who made a claim of actual innocence. And we started with a trickle of clients. And obviously it snowballed into something where we now have a couple of thousand people moving through the system here, more than 100 active cases. a network of 30 innocence projects around the country, and as much concern with policy and reforming criminal justice to make it more scientific, more reliable, more about the truth-seeking function. In most of our cases, the critical biological evidence has either been lost or destroyed. But more importantly, 90% of cases don't even involve biological evidence. And what it tells us is that there are obviously tens of thousands of innocent people currently languishing in prison in the United States. And so the Innocence Project is in a race against time, trying to help these people. And a lot of what you're going to be doing is running that race.
I'm going through letters, opening them up, reading through them, make sure they're not death row, so we can put the death row into the top of the pile, and enter them into the computer, their names, their addresses, and give them to the bosses, and they look through them and keep going through the piles and sending out letters and deciding what to do with the cases. We do pro bono legal work. There's only a few staff attorneys and regular workers that are paid and do this full time. So to get through all the letters, we have to have people like me, undergrads, doing intake.
All of these drawers, which are just literally full of cases, letters that haven't been opened, hundreds and thousands of letters.
I have a collect call from inmate Edge, an inmate at Cross City Correctional Institution. To accept, dial or say 5. Your call is being connected.
Nina Morrison's been real great. She's been calling me here about once a week, basically keeping my spirits up.
Hey, Welton, how you doing?
Warm. Hi.
Warm. Yes, I can imagine. Has the mercury hit 90 yet?
Oh yeah, it's been that for a few days now.
You hanging in all right? Yeah, you know, it's true, and I think it's hard because those of us who are on the outside forget. You know, this to us feels like the time when things are really moving, but I know that the days seem a lot slower and longer in there.
Same district attorney that convicted me in '84, he seems to be trying everything he can to keep me from going back to court.
That's a composite that the victim did, and she explains what she saw of the defendant, how he looked, etc., and they do overlays to, you know, yeah, that's it. That's the hairline, that's the way the hair was, you know, that's the nose and the eyes, etc., and that is the way the defendant looked at the time. I mean, you ask a victim to do an identification, and that's about as good as it gets.
Through the evolution of DNA technology, we can reveal a genetic signature that is unique in the human population based upon demonstrable proof. Having revealed that somebody is falsely convicted and frequently having to fight a battle to even do the investigations is not a sign that the system is working properly. That's a sign that the system's not working.
The only thing that's occurred up to this point in time is the gate has been opened so that this may be considered an evidentiary hearing. The defendant has the burden of proof.
It's not your intent to challenge DNA in terms of the scientific predicate, per se.
My challenge is as to all the DNA testing that's been done and what significance it should play in the court's decision.
I'm wondering if the state would mind providing us with the names and titles of the possible witnesses you may need to call.
It's a little late to be playing the discovery game.
Your Honor, I don't quite know what Mr. Holm means by playing the discovery game. We're going to produce the DNA evidence and what we have to do to get it before the court. That's our case.
From my understanding, it's an evidentiary hearing for a new trial and possible release, depending on what the judge decides. I'm hoping that he will dismiss the charges and will allow me to go home finally.
Have a seat in the blue chair if you would.
Hey, how you doing? Nice to see you. How's everything going?
Pretty good.
You know, we've been talking for a long time about it could be now, it could be now. I think the judge is ready to do the right thing. I think he needs to hear from the scientist, and he may find himself a little confused by the numbers tomorrow and need some time to think it over. But we're feeling good. And so, you know, it could be tomorrow, it could be next week. I wish I had a crystal ball and could tell you. I can't imagine what it must feel like at this point.
Kind of stuck. I'm not sure of this.
Yeah. And you talked to your folks? Were you able to call them from here?
Yes, ma'am. Good. Talked to them last night.
Good. They already said they won't let you wear street clothes, but we'll bring them just in case we need them later. Otherwise, I'll see you tomorrow afternoon. Okay? All right, try to get some rest. Yeah, it's a little loud here, huh? No. Okay, see you tomorrow. Good luck.
Hello. How are you? I'm good, thanks. How are you?
Good to see you.
Yeah. Hello. How are you? Good to see you.
Good trip.
I did. It was getting a little late.
See, this is bigger than what you can even buy in the grocery store. And that little one right there ended up having 3 tops to it. First time I ever had one of those to happen.
Really? Some kind of mutant DNA in there. Maybe we'll take the pineapple to court and say, Judge, those statistics are as reliable as this 3-top pineapple. So how are you guys doing?
I'm kind of like Wilton. I'm not trying not to build up too high.
Yeah. Well, that's probably smart. I mean, you guys have been through so much, and you've waited so long, and you've had your hopes up. I mean, when you first got the results back, I'm sure
we thought it was going to be quick.
Most prosecutors are inclined to do the right thing and at least give the guy a new trial because they know the evidence is so different. And I wish I could say what was going on in their heads now.
For a prosecutor to say, though, that eyewitness is better than DNA, I don't understand that.
Yeah.
And that was one of his statements.
22 years ago, there was no way to measure that. And now, there's a new study that just came out of all the people who've been exonerated in the U.S. over the last 15 years. And they found that eyewitness misidentification was the single leading cause of all of the wrongful convictions. And in rape cases, 88% of them involved mistaken ID.
We've got a place for Wilton when he gets here, and if he needs to make changes, we'll make changes or try to fix it up so he can be here as long as he needs to. But we're ready for our boy to come home.
Here's the point. This is new evidence. It's exculpatory evidence. Wilton Dedge is entitled to a new trial.
Right.
I don't care what they do. If they want to try to argue some esoteric thing from Venus, get it in front of a jury with a new and fair trial where we can present this evidence and then see what they say. That's the bottom line.
They pounded on the hair at trial. We now know the hair is not his. All go home. End of discussion. There is no other issue.
It is only a commentary on the state of Florida that you have to assemble this much talent in the room in order to get one guy out of jail that should have been released
3 years ago.
3 years ago.
More than 3 years ago.
Court notes the presence of the defendant, and we are all here on this matter. State of Florida versus Wilton Dedge.
We are here today, Your Honor, to close the circle in what we hope will be the final chapter in Wilton Dedge's 22-year-long ordeal. When Mr. Dedge was first tried, the prosecutor told the jury that the hair found on the victim's bedsheet was identical to Wilton Dedge. 3 years ago, we got the results stating that the 2 pubic hairs found in that bedsheet did not come from Wilton Dedge to a scientific certainty. We intend to show that the DNA evidence you're going to receive is not only admissible, but that his acquittal would be a virtual certainty.
Is a hair actually proof of innocence? The problem is that hair does not have to be from the perpetrator. The semen that was left does.
The 2 pubic hairs came from 2 different people and could not have come from Wilton Dedge. Is that correct?
That's correct.
Now, your lab, as I understand it, is working with some cutting-edge DNA. You now have a test that could be used on the Y chromosome to either include or exclude Wilton Dedge as the contributor of the sperm cell fraction.
Yes.
The state's belief is that we need to back up and the court direct that this evidence be tested.
Would anything that you do with the Y DNA, would that change your conclusions about the hair?
No. Hair evidence is definite. Those 2 hairs are not from Mr. Dedge.
Frankly, it was that simple then, and it's that simple now. If it was his hair, he's guilty. If it's not his hair, no jury would convict him beyond a reasonable doubt.
They got a hair that could have come from God knows where, and it's not Wilton Dedge's. And we ought to just say, let that man walk. Let the citizens of Brevard County find out if he really is a rapist. Let's find out the hard way, is what she tells you. There deserves to be some finality for victims, for the community. But these people don't have to be fair. They aren't fair. They don't want to be fair. This is Project Innocence.
After all of this to do about whether or not the state of Florida had the courage to allow a man to try to prove his innocence, when they fought for 3 years to keep from having this hearing and fought to not let the evidence be looked at, this is not supposed to be another trial. This is supposed to be about whether or not we have submitted evidence to Your Honor that Mr. Dedge would in all probability have been acquitted.
Because it is such a serious case, has such serious implications for everyone. I feel like I've been thrown a curveball on this a little bit, and so I'm going to have to take some time with it. And I have a comfortable level of satisfaction with regard to all other aspects of this case, but for the YDNA. So we will be in recess in this regard, and the court will consider that issue. Take care.
Okay.
We're supposed to be about ethics. There's supposed to be something called legal ethics. I'm horrified by this.
Wilton Dedge was very, very small, and the perpetrator was described as being very, very big. So this was an extremely weak eyewitness identification case, and 78% of the time in our DNA exonerations, it's been a mistaken eyewitness identification, the single greatest cause of the conviction of the innocent.
Is just how easy it is for truly innocent people to be wrongly convicted.
Wilton?
Yeah.
Hey, it's Nina. Listen, my dear, I have some really good news for you.
Oh, yeah?
We got the report from Reliagene, and you were excluded.
No, right.
They got a result, Wilton. They got 4 markers, and you were excluded at 3 of them.
There's no question whatsoever.
None at all. All we needed was 1 marker to prove scientifically that you didn't contribute that semen, and we got 3.
No, right. I'm feeling good. I'm feeling a lot better.
Well, listen, Wilton, you don't need me to tell you this, but you have done a lot, not just for yourself, but for so many other guys in Florida. I mean, you were the first, and you won't be the last.
Go ahead.
How are you?
And to the left. We usually have you stop and let them know who you are before we stop.
We're the Dedges to pick up Wilton. Okay. God bless you. Thank you.
same emotion.
Well, you don't look much.
You don't look the same either.
It ain't sweet on a night shift.
Morning. So what's new today?
I'm walking above the ground.
Oh,
So wonderful.
oh, thank you so much.
Thank you.
How you doing? Oh.
Fun.
Finally! Oh, great.
Sunday, then there's no more midnight check. Bye, my lady, I'll be back one day. Spent a long time stuck in the bed.
So now Beth will begin the conversation.
Thank you. I just want to take a moment to acknowledge what we just witnessed, and that several people here today have gone through incredibly arduous journeys like this, and several of our panelists have walked hand in hand with so many people that have gone through this process, some with successful outcomes and tragically some without. As Dean Carey mentioned, nationally, those proven to have been wrongfully convicted through post-conviction DNA spend on average more than 14 years incarcerated before they are released. As we saw in Mr. Dedge's case, it was even longer than that. Many wrongfully convicted people serve additional years on post-release supervision once they're released, whether that be sex offender registry or parole. And multiple factors have led to wrongful convictions. In Indiana, those have included mistaken ID, which we heard about in the clip, false confession, false accusations, false or misleading forensic evidence, official misconduct, and inadequate legal defense are a few examples of contributing factors. And the difficulties that innocent people face after years of wrongful incarceration are profound, including financial burdens, but additionally, access to jobs and health care and rebuilding family ties after significant time away from their families and shedding the psychological effects of years of wrongful incarceration. During the course of years spent wrongfully behind bars, many exonerated people missed out on educational and workforce development opportunities that they would have had access to had they not been wrongfully incarcerated. And they typically face serious medical issues upon release. Research has shown that the strain and trauma of prison, of years in prison, yields a higher incidence of medical problems for those who have been incarcerated versus those who have not been. The federal government, Washington, D.C., and 33 states have compensation statutes of some form that compensate wrongfully convicted people. Indiana is one of 17 states that does not compensate wrongfully convicted people in any way. 7 states in Washington, D.C. offer more than $50,000 for each year of wrongful conviction, and 9 states offer $50,000. And several states offer additional compensation for years served on death row or post-release supervision. Some states additionally offer social services, such as tuition assistance, medical coverage, job search assistance, housing assistance, and counseling. Today we'll hear from national and local experts on wrongful convictions in Indiana and the need for reform in regard to compensating the wrongfully convicted. We'll also hear directly from people who have been personally impacted by wrongfully convictions in Indiana, an experience that deserves our attention and action. I'm now going to turn to our first set of panelists. John, Fran, and Prosecutor Carter, can you just give us a brief introduction to your work as it relates to today's topic? John, I'll start with you.
Okay. Well, as I mentioned earlier, I started a nonprofit that I run out of California. I'm an attorney, but I do a lot of work that is a little unusual for an attorney because it's what needed to be done to address, at least in small part, hopefully in growing part, a lot of the difficulties faced by people who were in prison for things that kind of crimes they did not commit and who are now out. And so my goal was to try and think about the entire exonerated population across the country. That includes those who were not exonerated from DNA evidence, but for any reason. It also includes people who were released from prison many, many years ago because the absence of assistance from the state and the and difficult road has been faced by many for a long time. So I envisioned the population as originally hundreds and now thousands across the country, all who share at least this aspect of an ordeal. And the question was how to quickly get to as many of them as possible with something as serious as I could make it and helpful to them in reentry. And so I focus on access to healthcare, access to legal services, and also connecting to social services. And very quickly, it's pretty simple. I use my cell phone and I call exonerees all over the country and work with them one-on-one to make sure they're getting the health care they're eligible for. We don't sell anything, just try and assist them. And not only with getting it, but also making use of it, because it's obviously a core important thing that a lot of people aren't able to access or get use of, and we make the best of whatever is available to them. But where my project started was with this movie and with legal services. And so taking a step back, one of the stories in the movie you didn't see is of a guy named Vince Moto, the first DNA exoneree out of Pennsylvania. And in the film, he complains that he had been out for 7 years at that time, but didn't have his record expunged, his criminal record expunged. And so I was a new lawyer in San Francisco. I'd been out of law school a couple of years. I was working at a law firm, and I thought, well, we do these cases pro bono. Why can't someone just represent him? So I literally went to my office in the days after seeing the film and Googled around and built a list of possible attorneys to call in Philadelphia, where he lives, and started cold calling attorneys. And it was my second call, where I said, my name is John, I'm an attorney in California, will you give me 90 seconds to pitch a great pro bono case to you? And this happened to be a former US attorney, a former prosecutor who was then in private practice at a big law firm. And he laughed and he said, go ahead. And I told him about Vince Moto's case, and he said he'd take it. And Vince Moto had a lawyer, and I had a path to helping people. Not by doing the work myself, but by calling them up. And this was inspiring for me. Lawyers sometimes deservedly take a lot of heat in this culture. They also step up in a lot of big ways. You saw some of that in this movie, and I've now made part of my career going out and getting lawyers all across the country to step up for free and to help these folks, and not just lawyers, others. And so that kind of led me to think about what could be done. And policy is another area that we need a lot of help in terms of getting fair compensation statutes in every jurisdiction. And so I'm dedicated to that as well. To date, I've had the conversation and offer of services to more than 500 exonerees across the country. And I spoke with Wilton Dedge yesterday, told him that I'd be speaking here today and that you'd all be here today, and he sends his greetings from Florida. And I've also spoken in the last few weeks, actually, to 3 of the other exonerees that are in the film as well. And so we'll talk more about sort of both the problems and also what can be done. And most importantly, we'll hear firsthand from people who have lived and are living through it. But let me pass it on to Fran in terms of introductions of what we do.
Hello, good morning, everyone. Purdue Northwest Dean, Professor, thank you very much for hosting this event. I'm Fran Watson. I direct the Wrongful Conviction Clinic at IU McKinney School of Law in Indianapolis. So if we have any budding law students out there, catch me at lunch if you're interested. The Innocence Project is a national organization. The Indiana Wrongful Conviction Clinic does cases only in Indiana. We are a founding member of the Innocence Network. So I've been involved in this work since the beginning of the movement. And our clinic is very small. It's sort of a one-person operation, and we fight hard for our clients. We've done DNA cases. We've also done non-DNA cases.
My name is Bernard Carter. As mentioned, prosecuting attorney. I also like to thank Purdue for putting on this program. I think it's very important that we talk about this issue from every aspect. Certainly as a prosecutor, that's why I'm here. Not here to defend any type of situation, but I'm here to, I would say, seek justice in a way that I think it should be. I was at one time a Superior Court judge, and I recall mainly bench trials where the state just did not reach their burden, and I would direct them out, and I would chastise them for even bringing a case like that. I think what you have in many cases is very aggressive investigators. Many times you may have very aggressive prosecutors who are like in denial, and I say that. One of the things that I do in the office, and I've been prosecutor for 23 years now, the elected prosecutor. I was a deputy prosecutor before that, and I was a judge before that, so I kind of been around. In addition to my background and my understanding is I worked 3.5 years at Blackburn Correctional Complex in Lexington, Kentucky when I was in undergrad. And that provided me a very clear opportunity to see the criminal justice system and to see the flaws in the criminal justice system and to talk to inmates on one-on-one basis with no agenda. I wasn't there to do research, I wasn't there, I was just there to do my job. And I met and had a lot of friendships made from many of the inmates that I still have some contact with now today. There's not anything worse than a prosecutor, law enforcement, being involved in prosecuting a case that they know or have reasonable belief that this person may be innocent. There's no excuse for that. I mean, I think when you have a prosecutor or police officer involved in any activity like that, they need to be fired, they need to be jailed, and they need to pay the financial consequences. I truly believe that, in that 3 order. I'm on the IPAC, Indiana Prosecuting Attorney Association, executive board. In addition to that, I'm on their ethics board. And what we do is we lecture to attorneys, prosecuting attorneys, deputy prosecuting attorneys, as well as we set the format as to what the expectations are, if you will, as to being a prosecuting attorney. I truly believe that the majority of my fellow prosecutors are there to do the right thing and absolutely go out of their way to make sure the right thing is done. I'll give you a good example in Lake County as well as throughout the state. You would never, this does not justify a wrongful conviction. This does not justify prosecuting and putting a person who's innocent in jails. It does not justify it. But what I'm telling you is this. I know firsthand, because I deal with all the prosecutors in my office. I deal with prosecutors throughout the state of Indiana. Special prosecutors who come from other counties to come to my county and prosecute cases for me when I have a conflict. And I can tell you this, the prosecuting attorneys that I know and deal with, they go out of their way to make sure we have the right person as much as they possibly can. You know, we as prosecutors can't prevent lies. If a young lady says that she was raped and brutally beaten, and I've seen all kinds of situations where the husband beats her and rapes her and she blames somebody else. You know, I've seen all kinds of situations like that. But for a prosecutor, you have to go through steps to see and try to secure that witness is telling you the truth as best as you possibly can. They mentioned in the film about eyewitness. I don't like eyewitness testimony at all. Circumstantial testimony is the best for me. Eyewitness testimony, I don't necessarily believe people. Not that they're lying. They could be truly, and that's the tough part, particularly when you're dealing with a rape or things of that nature. They can be absolutely certain that this is the individual who did it. Absolutely certain. And yet it was not. And yet, if we tell that witness, no, there's just too many problems with this case, we're not charging this case. And this is the point I want to make, and then I'll let someone else speak. But if we tell them that we're not charging it, all mercy goes out. But the point of it is, when I lecture and talk to prosecutors, that's not our job to please that person, that witness. It's really not. If it don't match and it don't meet the criminal challenge of it, then we have to just set that individual down and inform them that. I bet you not once a month I meet with a family who has lost a loved one, at least once a month, and inform that family member that we're not charging this defendant. We're not charging them. And the reason we're not charging them, we outline it. Those cases are never heard of or don't think prosecutors do that, but we do that to a great extent. There's a lot of situations where the police departments, task forces come to us and say, this is what we got. Is it enough to charge? We want to charge. We think it's enough. And we look at them and say, absolutely not. It ain't going nowhere. You get us some more evidence or it's not going anywhere. In Lake County alone, we prosecute about 50% of the homicides. 50%. The other 50 go away. Out of that other 50%, probably 25% of that is presented to us as a viable charge. The other 25, they either don't know who the suspect is, they can't get witnesses to testify, all that. But we have about 25% of that margin that these people are willing to testify. They're willing to say, oh, Toby did it. And we look at it and say, no, I don't know whether Toby did it or not, but we're not charging this, we can't prove it. So you have good prosecutors out there who are trying not to make the mistakes that these individuals have faced. Absolutely have good prosecutors. And I'm always under the assumption that if a prosecutor participated in an activity that they know is not there, then that prosecutor should be prosecuted himself or herself. So I think it's a fine line for prosecutors, but we need to go out of our way to make sure that we are charging as well as convicting the right person. And if we're not, let that person go. Many times for minor offenses, if you will, I take the personal position as, boy, that's a 50-50. I don't like a 50-50 as far as a prosecutor. I'm talking about minor positions, not violent crimes. And I take the position, all honesty, telling the deputy, don't charge. If he does it again, we'll get him next time. If they don't do it, we win. But we got a citizen who's out there being productive. And if they do it again, then we need to come down on them. So you have very compassionate prosecutors out there across the state that have that mindset and will do that. Lastly, about compensation. I don't understand, and when I was talking to Dr. Jackson, I don't understand, and I talked to my fellow prosecutors, we ought to be in the forefront of that. We ought to be the ones saying, absolutely, if we make a mistake, a legitimate mistake, I'm not talking about something criminal like some of the things that go on in Chicago, but if we make a legitimate mistake, and this person serves 1 day in jail, well, 1 day in jail that deals with our counsel as opposed to the state funding. But if they stay any time in the penal institution, they should be compensated for that. They should be compensated, at the very least, with that compensation, apology, and whatever the case may be. You can't keep your head in the sand saying, oh, well, we thought we did the right thing and we're going to fight it, even though it shouldn't be fought. Thank you.
Thank you so much. And so, sure, you can clap. Fran, can you start us out giving a brief introduction of wrongful convictions in Indiana? Prosecutor Carter just mentioned eyewitness ID and touched on a few aspects, but can you sort of frame the topic of wrongful convictions in Indiana for us?
Yes. I mean, Indiana is just part of the whole, right? And there's this innocence movement now. And the innocence movement in Indiana and across the nation grew because forensic scientists dissected the human genotype. If science hadn't figured out DNA, so I like to say you've had DNA before there were universities. You've had, humans have those chromosomes, which creates that double helix, which creates 3 billion base pairs, which scientists were able to dissect and identify individuals. And that happens forensically in the late 1980s. So DNA as a forensic tool, Mr. Carter would tell you, we didn't have it. There are a lot of people went to prison based on misidentification, and there was no DNA to solve that problem. But in the 80s and into the early 90s, we were able to look inside the nucleus of the cell and pull out that strand and test that double helix. And that's what led to the knowledge that we've got innocent people in prison in lots of numbers. Because the science is a lie. If you're excluded, it's not you. And that's what has started this movement in some ways. Some would attribute that scientific advancement to the advancement of criminal justice that the movement's determined to continue. And Indiana is on that bandwagon. We have been since the beginning, really because my then dean, Norm Lestine, had been a criminal defense attorney. And before becoming a law school dean, he knew Barry Scheck. Barry Scheck reached out to Norm Lestine, and the dean sent me. Knock on wood. and it was very hard. I know those who've heard me speak before I always say, you know, the heroes in this room, the people that lead this movement now are at this end of the table. It's because of Roosevelt and Chrissy and Willie. That's why the lawyers are here. That's why Mr. Carter knows this is important work, because we all feel it, right? You don't want innocent people in prison. You don't want the bad guy to go free, and you don't want to be part of that system. You want to fix that problem. And that's our movement, and that's what goes on in Indiana and throughout the nation in this realm. And it was Barry Scheck, if you know the real history, it's fascinating. Scheck and Neufeld were public defenders. They had to learn DNA for this heinous case. And when they learned DNA at the very beginning, late 1980s, early 1990s, see, the lawyers don't understand it. Remember, lawyers go to law school because they don't do math and science. It's a joke, but there's some truth to that, right? But Barry Scheck figured it out. And he had this old case, and he went back and said, I wonder if that man who's been in prison all these years for rape that I defended and I believed was innocent, if this new science would help. And it did. And it was Scheck and Neufeld who figured out we should have law students do this. It's a great job for law students. So in part, the movement grew because law schools took up this task. And our law school, IU and McKinney, did that too. And so now there's really two organizations. If you're interested in more knowledge, look at the innocenceproject.org or the innocencenetwork.org. The Innocence Network is a national umbrella organization of all the law schools and not-for-profits and other organizations that do this work. And what's the work? To represent people and do what I call go upriver. Fix what happened. See, by looking at these exonerations, the scholars, your professors, can drill down into those facts and look for common variables. And then we, the movers and shakers, you, the future leaders in the criminal justice realm, we're going to go back and we're going to try to fix this, right? We're going to try to prevent it upstream, see, as much as we can fight for the cases that are there. And again, the movement, if it wasn't for these individuals' willingness to come into this room and relive their own pain and relive their own trauma and share with you, it would be not near the strength of our movement. And so I always, want to give credit where credit's due. Go back up to Barry and Peter, who had a vision and got this going in many ways, and then realized that our exonerees are very and critically important to the reform. And so what are those issues across Indiana and the nation? It's access to evidence and DNA testing, exoneree compensation, false confessions. It's counterintuitive, but people do falsely confess. Absolutely. How do we know that? DNA. If it's not your stuff, it's not you. Eyewitness ID, ineffective assistance of counsel. I teach in a law school. I preach about how it's the lawyer's fault lots of times that the truth doesn't come out. Both criminal defense lawyers and prosecutors. They carry that responsibility together. There's a lot of use of snitches that doesn't lead to truth. There's police and prosecutorial misconduct. I've had, Mr. Carter is not one of the prosecutors that resist turning over stones. He's interested in the truth. But there are prosecutors out there who resist that. Not the majority, but some. And then there's the use of unreliable forensic science. There's false science. You heard this morning in the clip about hair that was matched to an individual, and the jury thought they were hearing that was Mr. Dredge's hair, and it wasn't. And the same happened in Mr. Glenn's case. He was convicted with a hair that was said to be from him and couldn't have come from anyone else, and of course it was not his hair. And so I'm glad to be here today to talk about compensation, because Indiana needs to get on this bandwagon. Thank you.
Thank you, Fran. John, can you talk to us a little bit about you're talking to folks when they're being released after going through this long journey. Can you talk about some of the immediate needs and some of the long-term needs that you see folks continuing to struggle with years after?
Sure. First, I want to take a step back, though, and just comment on what we've just heard briefly, which is there are many ways to look at problems, and we're in a very contentious time, obviously, in our country and locally. One of the things that's exciting to me about the prospect of reform in the area of exoneree compensation and post-release assistance is I see it as a nonpartisan, non-political thing that we should all be able to get behind, because I think that with very few exceptions across the spectrum, people get it. They get that if you can show that you were not the person who did the crime, you deserve something, I think, generous, at least reasonable, to help you, to compensate you for the time you lost and to help you on your way. And the reason I bring it up is that we often get caught up in the conversations about the why it happened and the who's to blame. And those are very important questions, and ones we need to look at seriously. But at the end of the day, it shouldn't be on, I hope we can all agree, it shouldn't be on the individual to prove that it was someone's eyewitness mistake or someone's bad actions in order to get what we should provide them. And I think that this issue asks the question, what does a good society provide to someone that its own justice system identified should not have been there in prison? Full stop. So anyway, with that, the issue of coming out it's strange to sit up here and talk about it with three people who have, and I want to defer to them later on, but also answer Beth's question with my own experience for what it's worth. People often say, sort of, what happens to these folks? And they often think that, well, three things. They say to me, surely the state must be compensating them for what they went through. And you have already heard that in the state of Indiana, you're entitled to exactly nothing by statute. And the reason for that is that you don't get anything in our system unless we provide for it, right? And so one thing is they're not getting something when they come out in most places, including in the places where the 33 states, if you look at them carefully, you'll see that many of them have tremendous hurdles to getting the assistance provided. And we can get into that in more detail, but it's just not the case that surely you get money when you come out, even in the compensating states. The second thing I hear a lot is that the organizations must be taking care of these folks in some way. And unfortunately, that's just beyond the mission and the capacity for most of the organizations. A few of them do post-release work, and we collaborate and so forth, but the vast majority of them simply, their job is to get people out of prison, and although they want to see people do well, they turn to the next case. The third thing is really puzzling for folks, which is most people think that they must be able to sue. And that's a totally understandable idea because we read in the newspaper all the time, see on TV about people suing for this, that, and the other thing. And when someone apparently gets millions of dollars for something relatively minor compared to years and sometimes decades in prison for a crime you didn't commit. And the reality in the law is in America, everywhere in America, is that proving that you were in prison for something you did not do is never a basis for a lawsuit, a civil rights violation in the United States. So every time you read about someone who gets millions of dollars for wrongful conviction, it is always something in addition they have to prove. And that thing in addition is they have to prove deliberate wrongdoing by a state actor, and there are many hurdles there as well. And the really important thing to understand that here is that what that means is that if you take any group of exonerees, they may not have a lawsuit to begin with. And that's not their fault. So that's one of the other reasons we really need to have a compensation system that's based on simply the harm that they endured by being in prison for something they didn't do, full stop. But in terms of that leaving them with nothing, most of them, what I see a lot in them getting out is they have to face what life is like for being a formerly incarcerated person in lots of ways in the United States, which I imagine a lot of you have heard of with our mass incarceration problem and the tremendous difficulty of what it is to come out after, in quotes, you've paid your dues. You haven't. We do not make it easy in most places for someone who's spent time in prison, and in many ways we set them up for failure. And exonerees are in a very strange situation relating to that. In one sense, they're very different, right? They didn't commit the crime, they are innocent. But imagine what it's like for someone like Wilton Dedge, or any exoneree, some number of months after release, and they go for a job or they go for an apartment, and someone pulls their background sheet and they see, or they ask for a resume, and there's this big old long gap, right? And the chances that they're going to be able to turn what should be something that would work in their favor, who wouldn't give Wilton Dedge a job, right? But only if you saw the film. Because if you didn't, Wilton Dedge is someone with a 22-year gap in his resume, right? And may still have some mention of the conviction on his, maybe, and what's he going to do right in that moment? He's going to say, no, I'm innocent. Let me show you this video, or let me show you this newspaper clipping. And even a decent landlord or employer could quite easily be understood to kind of be like, well, wait a minute, I got a lot of other people who want this. And we have a tremendous difficulty situating these folks for what they've actually gone through. And one of the great byproducts of a compensation statute is it can actually help. Because one of the things that compensation statutes should do is they should really be a state certification that you were getting this money because you were not the person who did the crime. And if you can have that, and we can, for example, in Indiana, create like a certificate of innocence that they have in Illinois, that might be a help. Won't get you all the way, but that might be a help. But I don't want to go on too much longer, and definitely want to hear from the exonerees that are speaking to us later. But the difficulties are legion, tremendous. They don't have access to some of the assistance that we provide to parolees. People are astonished about that. It makes complete sense. We set up a system of, in some places where I live, there's a halfway house for someone who gets out of prison if they're on parole, which has curfews and has drug tests and things like that. The people who run that are told, you take parolees. Well, my client from a few months ago who got released because he was exonerated is not on parole. So he's ineligible, he had no place to live. And there were many other examples of this. In addition to, obviously, the mental healthcare issues and PTSD and trauma that comes for having endured not just our prison system, but having been wrongfully convicted and innocent in our prison system. But the bottom line to all of this is the remedy is at least partial remedy, is a thoughtful statute that really takes a look carefully at what they've been through, at what they're gonna face, and what we can do to help them in really concrete ways that fit into your system. So.
Prosecutor Carter, so the name of today's event is Righting a Wrong. Can you talk a little bit about the duty of the justice system to right the wrong of wrongful convictions from your perspective?
Yes, as I mentioned in my onset, I think the justice system, you have to break it down. You're talking about the court system, you're talking about prosecutors, you're talking about the penal institution. Let me just concentrate on the prosecutors. The prosecutors throughout the state are very powerful individuals. And by statute, they're given a lot of discretion. And by statute, they can present under most circumstances certain things in terms of agreement, PCRs, and agreement to what comes in, what does not come in. And with that comes a balance with the prosecutor, as I mentioned earlier. You have to have the heart, the passion to get at justice, whether you felt it the first time and the person was convicted and now it looks like, you know, I have to say Fran is just such a tremendous person to work with, because I don't see her, now my attorneys do, but, and I'm not hiding behind them because that's their job, but she's a very compassionate person and I'm not adversarial to her. And I'll listen and I'll review anything that comes down the chain from her to get at what we can reasonably say the wrong has happened and it needs to be corrected. So I'd like to thank you for that, because it really is a blessing to the prosecutors of what the Innocence Project does. I'm not adverse to the whole concept of trying to review and find out who's in the penal institution that should not be there. I have no objection to that, and I think it's kind of asinine and crazy for prosecutors to take that position. But I tell you, for the most part, I mentioned a little bit earlier, we are manipulated, if you will, we truly are, in a right way and a wrong way maybe, to victims. I've had to dismiss a couple cases or agree to PCRs where I have particularly rape victims, and I had to sit down and explain to them 20 years later, this is why we're doing this. And they're as compassionate and adamant as the day that we prosecuted this case. 20 years later, they're like, no, I don't want him out. No, absolutely not. Where am I going to go? And I'm saying, you don't have to go anywhere because he didn't do it. He's not going to come after you. And so prosecutors have that to deal with too. And these individuals, many of them, they create their groups and they go to the press and they say justice is not being done. You got a liberal prosecutor here. Technically speaking, prosecutors don't really want to be known as liberal. They really don't. They want to be known as doing society's justice, really, truly, But in essence, a lot of the prosecutors go overboard with their, how should I say it, inability to listen and inability to see the other side when they know they should be able to see the other side. And they're more in a position like that when you start dealing with post-conviction release and you start dealing with people who serve time and serving time in jail. As I said earlier, many times we'll look at a case and we'll dismiss it in terms of not even charging it. We'll just say there's not enough evidence. There's probably a preponderance of evidence, but there's no beyond a reasonable doubt evidence. Police officers have to file, and many of them, I lecture on this all the time, police officers have to file based on probable cause. That's all they need. And many times probable cause don't get you past a directed verdict. And we as prosecutors have to sit there and say, it's not going anywhere. And I think that's very important to understand, is that many of these cases that people have served long terms, there's a lot of people who have not served any time, not charged at all, because prosecutors have done the right thing and called it like it was. But when I start looking at some of those cases, it's usually ones that the victim kind of acquiesces a little bit and the victim's not so certain, or whatever the case may be. Because, I hear victims say, well, I believe if you had to quantify it, 75% chance that's him. Well, I don't want to do that case. You're talking about 75% chance. I mean, why would I want to put somebody when there's a 25% chance this is not the person, absent some other type of evidence? So when you start dealing with eyewitness testimony, that this is the individual, I strongly believe that we have to have other evidence to go to that, and other physical evidence and circumstantial evidence to lend that way. What's going on now with the telephone, and the telephone is essentially a computer, and we get so much from the telephone with coverage as far as following an individual, locating an individual, or where an individual has been. So that's helping us in many ways put an individual right at the scene, So that helps in terms of certainty, and helps in terms of comparing it with a witness that you're looking at and she's testifying or he's testifying that this has occurred to me. So I think really the essence of it is the prosecutor is really in the key position to review what the police do, and don't close your eyes to it and don't buy into it. And I tell our attorneys all the time, when a detective brings in a case, question that case. Even say, well, let me think about this here and I'll get back with you. Take time, come in and talk to me, talk to one of the other supervisors. Every case is very important. I look at it also from an economic standpoint, not only from going to jail, obviously, but when we make a decision to charge someone, I don't care whether it's a poor person or a rich person, it don't make no difference. The expense that is involved for that person to be charged when we know we don't have enough to prove a guilty verdict, like we're going to take a chance or something. We're not in the chance business. We're in the beyond reasonable doubt business. And when the police comes in with a probable cause affidavit, it don't really lend itself to a conviction by us, because we don't know whether that person did it or not. Do we have the right person, or is there enough testimony coming forward from that person? then we have to do, as prosecutors, do the right thing. And what I'm saying is, to a great extent, prosecutors have to kind of lend themselves to not let a victim or not let a person who's being harmed, like on a burglary situation or something like that, and the person is seen with the merchandise 3 days later, and that's all the evidence you got. Well, you're not going to charge that. If you caught with the evidence 5 minutes down the alley from the house, and I've seen cases where a guy argued, well, I was walking down the street and saw it there, and I picked it up and ran with it. How do you prove that he didn't do that? But it's just, what do you reasonably believe? So to say that, I'm asked all the time in forum meetings and when I talk to people, are there innocent people in jail? Well, clearly we know that. There's no doubt about it. How many? I don't know. And under what circumstance, I can't really tell you that too. We have witnesses who will lie and stick with it and put people in jail. We have witnesses who will testify and misidentify an individual and go with that. And we as prosecutors have to really read through it. So I say it really stands with the prosecutor. The court doesn't, as a judge, a former judge, and as a court, the court doesn't stand in the way of much. They may suppress something as far as the prosecutor, or they may allow something in that the defense don't think should come in on some type of suppression hearing, things of that nature. So they make some important decisions, but it's the prosecutor who brings that and know whether we have a valid search warrant or know we have a statement made. A few years back, the Supreme Court came down with a rule that we have to tape all professions. But we still have occasionally people who just don't understand that. And they have to basically have an interview in the car, taking the person to jail, and think we're going to get that in. There's some cases say you can get it in under a certain circumstance, but why do they do it? So they make mistakes sometimes, and those are suppressed, and it is what it is. So that's going to be my answer. It's the prosecutor, and then certainly the courts play a part in it. But you have to have prosecutors who do the right thing.
Fran, so John touched on this briefly. I'm wondering if you can elaborate for folks, what is the process for someone suing? John mentioned people see on the news that people receive settlements and may assume that folks who are wrongfully convicted are indeed compensated once they go through that process. Can you spell out for folks what that mechanism actually is and why that is not a wholesale mechanism for ensuring everyone is appropriately compensated?
Sure, I'll give that a try. Can you imagine, put yourself in the shoes of someone who's just been wronged by the criminal justice system, and the players in the criminal justice system are lawyers and judges. And then when you get out, you've got to find another lawyer. In Indiana, see, there's no compensation. You don't have a choice. If you're going to try to get compensated, you're going to have to file a lawsuit. And so you have to go back to that system that put you there, that slow system. Do any of you individuals think it's fast enough? See? So in Indiana, if you want to try to fix what's been done wrong to you, you have to go back to the system. You have to relive the case. You have to relive the horrors of those wrongs, and it takes years. Lawyers are slow. The system is slow, particularly if you sit in the seats they do. There's, in most cases, individuals file these lawsuits, and as you heard, in the United States of America, it may not be okay with you, but the present law, which lawyers like us would like to change, is it's okay to execute someone if they're innocent, as long as they had their constitutional rights upheld. Everybody okay with that? Anybody okay with that? It's okay to execute the innocent in our country as long as they got their constitutional rights. And that's the takeoff from what he's telling you. It's not a cause of action that you were wrongly convicted. To be compensated, you have to prove that the Constitution was violated either by an entity, the government, or an individual, the police officer. And guess what? There are these legal defenses called immunities. So prosecutors and police officers have what the law calls an immunity, which means you could be wrong and still not have to pay. Immune means you're just immune, not that you didn't do anything wrong. So that's the difficulty. in Indiana, for our exonerees, when there's no compensation statute, they need money when they get out so they can live and eat and get health care and get cars and go to work. And there's no pot of money there to do that. And so they turn to lawyers and they turn to litigation. And if they're in federal court, in all likelihood in Indiana, and I'm generalizing, they're going to lose summary judgment at the trial level. And then they're going to have to go up to the 7th Circuit in Chicago and hope that the 7th Circuit sends it back to the trial court and says that they can have a trial. And that's the journey that individuals in Indiana, it's the only journey that they have available to try to become.
I just want to piggyback on what Fran said. My students have heard me say this many, many times, but for those of you who have not sat in my classes, let me share with you that in the state of Indiana, people who are released from prison who are truly guilty of the crimes they were convicted of, they are provided some services. They have a parole officer, they have reintegration services available to them. However, in the state of Indiana, if you were exonerated, meaning you were not guilty, you were truly innocent of the crime you were, for which you were charged, we provide 0 services. So if I may, just to share with those of you who don't know me, how this came to be, why we're all here today. I know you're all anxious to hear from these 3, because I know that, and that's why we're saving them for after lunch. So that ensure, I mean, the panelists have done a great job, and first I want to thank, gosh, we've got people who flew in from, John flew in from California, and Beth flew in from New York, so I mean, I think they deserve a big applause for being here. We drove about, maybe 20 miles, so I mean, that's, I truly appreciate, and Purdue really appreciates your being here for sure. Just so you all understand how this came to fruition, I had read an article in the newspaper, was it about 2 years ago? 2016, and I saw a picture of this gentleman sitting next to me, and I read about this guy serving 24 years in prison for crimes that he didn't commit, and I thought, wow, how could anybody sit in prison for 24 years? I have a, undergrad, a master's, a PhD. I've been studying criminal justice for decades, and I'd never really thought about those who've been sitting in prison who truly are innocent. I sit on the advisory board at 2 prisons, at Indiana State Prison and at Westville Correctional Center, where these guys probably spent some time. And there's just this, I think, presumption that most everybody sitting in there is guilty. So I read this article and I thought, man, how could this guy have sat in prison for 24 years? So I did what any good professor would do. I called the prosecutor. I called Bernie and I said, hey, I just read this article in the Times newspaper or the Post-Tribune, whatever it was. Is it true that this guy spent 24 years in prison for crimes for which he didn't commit? And Bernie, do you remember that conversation, Bernie, at all? I know we have a lot of conversations, but I don't know if you remember that one. But I called him on a Sunday, actually, so I was surprised he answered his phone, because he never answers his phone. So at any rate, that's a whole different story. But he said to me, this guy is 100% innocent, and I won't ever forget that statement. And I was like, wait, he's 100% innocent, he spent 24 years in prison. Okay, something just isn't sitting well with me. And so I had contacted the columnist who wrote the article and said I wanted to meet Mr. Donald, and he said, why don't you contact his attorney? And so I did just that. That very day I called Mr. Vaines, who was Timmy's attorney, and I asked to meet with Mr. Donald, and I think we met a day or 2 later. And I made a promise to him, and we'll share his story and Roosevelt Glenn's and Christine Bunch's after lunch. But I made a promise to Timmy that I was going to be a voice for those in the state of Indiana who've been wrongfully convicted. And this is not my area of research. I'm a social scientist, as Dean Carey shared with you. You know, we go out there, we do research, and sometimes we end up on a very different journey than we expect. You know, my area is domestic violence, but I work with victims. I've worked with sexual assault victims, domestic violence victims, and these three sitting up here are victims. They are victims. And we need to recognize them. And I know there's many of you in my victimology course sitting in here. These are our new victims. The panelists have been on this journey for a very long time. I'm really new to this game, very new. But for those of you who know me, know I'm very loud. I'm very persistent. I don't give up. And when I heard about Timmy's ordeal, which you'll hear about after lunch, I knew I had to do something. And so what I did was something that you all may be doing in the future. I mean, if somebody told me when I was a college student I was going to be making phone calls to some pretty big players, I would have told you that would never happen. I made a phone call, or excuse me, an email. I wrote an email to Barry Scheck, who was one of the attorneys on the Dream Team for the OJ case, which is what he's probably most famous for, right? And so I emailed him thinking, oh my goodness, he's not going to call this or email this professor from Purdue Calumet at the time. He didn't even know Purdue Cal probably, so you know, I'll probably never hear from this guy. The next morning, I checked my email at 8 a.m. There was this amazing email from Barry Scheck, and he connected me with Beth's agency. Beth wasn't there at that time, and the policy director, Rebecca Brown. And he connected me to Rebecca, and she and I had a lot of conversations, and I was horrified by how many cases of wrongful convictions there really are in this country. For those of you who are interested and want to know more about wrongful convictions, and you want to find out about exonerations, there is a national registry of exonerations, and you can actually go on there and look state by state, and all of these folks are listed under the state of Indiana. So I would encourage you to go look at that, and let's hope that this doesn't happen to somebody that you love, doesn't happen to you. And I know I have children, I have students, I am, I think, a compassionate person, and I knew that we had to get together, we have to have dialogue, we have to have discussion on this issue, because things won't change in the state of Indiana unless we have these conversations. And that's why we're all here today, because I think everyone up here is very passionate about righting this horrific wrong. John, I wanted to ask you a quick question, and Beth, I promise I'll be quiet. I'll try. Well, I shouldn't make any promises because I'm not very good at that, being quiet. But John, what happened to Mr. Dedge? What's he doing now?
Today he's on vacation. He's living in Florida and enjoying himself, basically having a good time, traveling around, seeing relatives. He eventually was compensated through the Florida legislature, he's
working?
Living his life. He's not working. He had a business for a while. He's taken a break from that now, and I think he's thinking about his next move.
He says he wanted, if his goals were career and family. Does he have a family now?
I don't believe he has a family. I mean, he has family members. He's visiting a cousin right now, but I'm not super well informed on how he's doing on that particular front.
I was just curious if he was married now.
Yeah, not married now.
So one of the things that I had heard from Timmy when I met with Timmy, and we will go through his stories, all their stories shortly, but one of the things that really, I think it really was upsetting to me was when Timmy said, you know, he's in his 40s. He's like, you know, he calls me Mrs. Jackson, and he says, Mrs. Jackson, I may never have children. I may never have children, and I have 2 kids, and he does call and ask about my kids all the time, which is pretty amazing to me. But that was just something that was so hard for me to understand. You know, we've taken this life and we've locked it away for 24 years. And now how do we right this wrong? And one way we can start, and I know my students have heard me say this over and over and over, is we've got to get a bill written in the state of Indiana, And for those of you who don't know, I have had the pleasure of working with Fran, Bernie, Beth. We've been talking with legislators in trying to get a good bill put together. So these guys and gals will be taken care of, at least financially. I mean, there's a whole other aspect with health and psychological care that I'm not sure how the bill will you know, whatever bill we present will look. But this is why we're here. And I hope that each and every one of you, when you leave here today, you will share what you've heard from our experts, from our exonerees, with those, you know, that you, your family, your friends, share those things, share what you've learned today with them, because this is not something people talk about. This is really kept behind closed doors like domestic violence used to be. And I applaud Mr. Carter, our prosecutor for Lake County, who is very, you know, people said you're never going to get a prosecutor to support you in this, you know, endeavor. And I said, you don't know our Lake County prosecutor. I know him personally, I know him professionally, and I know he cares about justice. And I think Fran already said that. And I wish we had more prosecutors like that. So Bernie, thank you, you know, for the residents of Lake County. We've got two exonerees up here from Lake County, and they're clapping. I'm like, wow, that's pretty cool. That's awesome. So Beth, I'm sorry I took over your questions. Oh, Timmy wants to add something.
Please. For one moment. I know in many cases people always think about exonerees as being male, but there's a lot of females that's exonerees. Christine's up here at the panel, and I remember an experience I had at the San Antonio Innocent Project conference, and I had went to the, you know, they had many forums, John, you know, they had many forums, and I went to the women. That was the first one. Yeah, I went to the women conference, and you should hear they horrifying stories, and most of them is just like twofold, because they already in prison for something they ain't did, and most of it's like, you know, it may be a child or their husband, so they got a twofold problem they have to deal with, being wrongly convicted. And I think the women should be acknowledged as well as the men. I think, you know, women should be acknowledged more.
So you're saying when you went to this, I remember when you went to this conference, and you, one of the panels you went to dealt with females who had been wrongfully convicted, and one of the things, I remember you calling me from San Antonio and sharing, you know, a lot of what you learned, which was pretty cool. But one of the things that was, I think, surprising to a lot of people was that women who are wrongfully convicted are typically wrongfully convicted. Is this what you learned about killing or harming a loved one?
Yeah.
Because we don't expect women in society to harm their children.
Every time they say they speak males, and it's females that's been wrongly convicted also. So.
Thank you.
So, thank you, Dr. Jackson. I'm actually it's a perfect segue into talking about the legislation. And so, John, I'd love if you can sort of walk us through two things. The different bills you've worked on around the country, how different states handle this. What are some of the key elements that are critical in compensation? But you mentioned in a comment earlier that even some of those 33 states we mentioned that have laws, there are significant hurdles that often people who we think, oh great, there's a law in place, people will get compensated, they still don't. So can you talk to us about the key elements, but also maybe some of those hidden barriers that folks might not be aware of?
Sure. It's a rough landscape out there, even where there are compensation statutes. We're not going to make it up to them fully ever, right? I mean, time is the only thing we really have, and you can't get it back. What we can do is we can come together and we can be serious and honest about what happened, and we can say we will not be able to give back time, but that does not mean we do nothing. And in many places we do nothing, and in many other places, as I mentioned earlier, and Beth just reminded us, there are laws on the books, but they're not actually doing the work that one might expect them or hope that they would do. And just so you don't feel too bad about being in a state that doesn't have compensation, as a compensation statute, there are states that have them that compensate almost no one. There's a state out there that provides only free tuition at the state university and no money at all. There's a state out there, a couple of them actually, that require that you get a pardon from the governor, which is an entirely political act, right? There's no right to it. The governor doesn't even need to respond. And we have people lined up, stone cold innocent, unable to get any compensation because they can't get any relief through that particular barrier. We have many instances where the social help is not actually being delivered. So the first thing we can think about is what do we want to do and what would be right? And as we craft the statute, we can think about some core issues that are present both in every statute and also really to every society. How do you decide who is eligible? And what is your sort of criteria? And there are sort of technical legal discussions to sort of figure all of that out. But they need to be informed by, I think, common sense. What are we trying to do here? Are we requiring someone to show innocence to the same standard as a prosecutor must show guilt? Are we requiring them to simply show that their conviction was overturned and the charge is dismissed? Is it something in between? We should have really robust discussions about what is the right way to cut it. And then we should look at the real cases out there and say, you realize that by doing that, here's who you're going to compensate and here's who you're going to leave out. And I would argue that we should err on the side of generosity. And the reason for that is that the fiscal impact is tiny. This is not something that will kill any state's budgets. It's certainly in the money that we're typically talking about giving these people around the country. The other thing is that we are going to make mistakes. The whole idea is we make mistakes. We're not perfect. The entire justice system is built around the notion of mistakes. That's why we have appellate courts, to give the opportunity to discover an error, right? We're never going to get it, even if we get the best prosecutors with the best attitudes and the best police and the best juries, the best of everything, we will still have wrongful convictions. We'll have fewer of them, and we should do everything to minimize them, but we will never, ever get rid of this problem. Ready for a bummer? We will also never get all of the people out of prison who are innocent. Because for every one of these Wilton Dedge stories you see, there's someone else. You saw what happened. They had to test the sperm, they had to test the hair. There are plenty of cases that old where the evidence has been thrown away. Or they tested and it's inconclusive. Or there was no biological evidence to begin with. And if you look at these cases, you can't help but be struck by just how crazy, and this is a crazy word to use, lucky we are when we get someone out, because it turns very often on something that so easily could have not come to light. I want to recommend to you one quick 3-minute clip on StoryCorps, if you Google it, from NPR. And it's a clip from another exoneree, Ricky Jackson. And Ricky Jackson is interviewing the man who at 11 years old was coerced by police to identify him as the person who committed a crime that he had nothing to do with. And Ricky was sentenced to death, was ultimately changed to life in prison. He spent 39 years in prison in Ohio. And in an extraordinary few minutes, he interviews the kid who, at 11 years old, this is now 40 years later, that kid came forward 39 years after the conviction. That man, he could just as easily have gone longer or to his grave, and Ricky Jackson would still be in prison, no question about it. There are hundreds and hundreds of stories of just how close we come. So sorry, I went a little long here, but the reason I say all this is that when we construct this regime of compensating people, we can afford to err on the side of, because we will, every once in a while, not get that right too. But we should do it by maybe compensating somebody a little more generously and a little more to a lower standard than leaving people out. So anyway, what does a compensation statute look like? Well, it has to define who gets it, right? And that's something that we should have a good discussion about. And it shouldn't be, it should include the class of people that we typically talk about as wrongfully convicted, as on the registry of exonerations, which is an academic database, something you really should check out. It's fascinating. It's exonerationregistry.org. It's maintained out of the University of California, Irvine, and it attempts to collect and profile the exoneration stories and cases. And what's unique about it is it's academic standard, it's a legal standard. It's not just anyone who says I'm innocent. Everybody has to pass an investigation, essentially, and before they're profiled up there. And it does leave people out who are innocent, but it's still a very good start. The next thing we can talk about is who decides. Are we going to have this go to a court? Are we going to have this go to a civil board? How do you want to do that? Another sort of administrative thing that you're probably not terribly interested in. Let's just make sure that it's fair and listen to everybody. Robust conversation about what this should look like. The next thing, obviously, is where's the money? How much money? But here's a really important thing that I hope we can get at in Indiana. What's the money for? If you look around the country, as Beth said, you have a number of states, 9 states or something, that provide $50,000 a year. What's that for? That counts your compensation based on the number of years you're in prison, which strikes me, at least common sense wise, is saying, okay, we'll give you were in for a year, you get 50 grand, you're in for 2, you get 100. But what about what happens to you afterward? Is the concept that all we need to do is compensate you for what you've been through? Because that's not what we do in other places. When you get, God forbid, hit by a car, you're not just compensated for your lost wages from the work, you're also compensated for your pain and suffering, but also what comes afterward. There are very few compensation statutes that look to what comes afterward. And a generous one, and let's have a discussion about it, would be what do you want to provide for people in Indiana who prove that they were not the person? Let's get that over with. They are not the person. They did not do that. What do we want and how do we want to measure it? That's a really interesting question, and I hope we can get to a good response and a bill that can pass the legislature, of course. Another piece of it is what else are you going to provide that is something other than money for time? Are you going to try and provide some assistance to an exoneree in terms of other things like job training, like some kind of mental health or enhanced social services? Are you going to try and provide some kind of education opportunities? And my request there is, again, a very serious and practical discussion, because it doesn't do good to say you get tuition at a state school when they, can't afford to go to the state school or can't get into the state school, or there's no bureaucratic provision for them to actually get that. And so I hope we're careful, because what we really want to be is good to them and also good to ourselves, because you are the state of Indiana. You are taking over Indiana. You're all already voting age, I imagine. This is your state as much as it's anybody else's. This is your system. It's not, you're electing this gentleman here, right? You deserve a system that is honest enough to say, hey, we're going to make mistakes, and when we do, we're going to provide a fair system where people can come to the door and say, I'm one of those mistakes, and then we can be generous, which doesn't necessarily mean civil suit gazillions of dollars, but also doesn't mean what is currently provided around the country, including here.
So I think everyone here who's worked with the legislature, worked on policies, will tell you it is a very slow process, despite what we've heard that this is a bipartisan issue that anyone who's been here today can tell you is so obvious, right? It is such an obvious issue. That does not mean it is by any means a light lift or something that is certainly going to happen. That said, on a quick logistical point, we'd love for folks to stay engaged. So there is a sign-up sheet out front where you can put your email down. We'd love for you to stay engaged as this process continues so that you can be a part of this journey. I want to leave a little time for questions, and we're down to about 20 minutes with this first panel. I know everyone's very, very eager for our second panel, as am I. So I was wondering if folks from this first panel could just give us some closing thoughts for the audience before we head out and take a few questions.
I gave one just now.
Actually, I have a question. Can we just ask a question? So, John, I know there's been some discussion about in a whatever a good bill will look like. There's been conversation about whether those who've been wrongfully convicted should be allowed to also sue. And I know my position is they should be allowed to sue along with getting compensation, okay? Particularly when in these cases there were wrongdoings in their convictions. What's your feel? You and I have just met today for the first time, so we're actually having this conversation in front of all of you. But do you mind me asking that?
Not at all.
Okay, so what's your feel on that?
So I have very strong feelings in two ways. One, about what there should be, or both about what there should be. Before I answer your question, what we ultimately need is a compensation statute. And that's the most important thing. And it doesn't mean I'll be happy with anyone. But as Beth said, this is very tough. It will not be easy. It may take years. I hope it won't, but it may. And we need your help. And that means staying engaged, telling your friends, and building the popular support that moves your politicians, because that's what they listen to. And so I want what is possible. But if you asked me, absolutely, we need, for the reason I mentioned earlier, there must be a compensation statute, because we already have in every state people who can demonstrate they are stone cold innocent who have no lawsuit. So earlier Fran was talking about, we don't have one, so you have to go find a lawyer. I speak probably every week with an exoneree who would not find a lawyer because lawyers don't take cases where there is no case, right? And if there is not provable wrongdoing by a state actor, right, and really by a cop or a policeman, who's a police officer, law enforcement officer, and not a prosecutor, it's very difficult to get liability from a prosecutor. You have no case. So, we really need the compensation statute, simply must be there, and it's a part of our integrity in having a system that seriously grapples with the inevitable errors that we're going to have, right? Separately from that, it is in our interest to have the wrongdoing exposed, and it only comes out, in many instances, through a lawsuit. It's not pretty, it's not good, it takes too much time, it's expensive for everyone involved, but if we simply write off the lawsuits, we lose, because we don't find out about the policeman who hides evidence, and I don't think they all do, right? But they're in every system. You're going to have people who are bad actors. It's just inevitable. How are we going to find them? This is one way. And so I feel very strongly that we have an interest as a society in some way of learning about these errors, and most importantly, correcting them. The realities may make it, and we'll get into that as we move instead of the statute and a bill, but I feel strongly that people should be entitled, really are entitled to both, because they're very different. One of them is about the harm you endured for being in prison for something you didn't do. The other is about the harm that was done to you by someone who did something they shouldn't have been doing. And those are very different things, but we need as a society to have a mechanism to know and to take care about both.
So I have another question. Brian, how do you, I know you get lots of letters from inmates, because I get them, and I'm not an attorney, so I don't address those letters. But what's the process when an inmate writes to you and says, I'm innocent?
Well, generally speaking, we have intake, and we review the material we can find online about the case before we send back correspondence that says, put you in, we know we can't help you, we might be able to help you, we need more information, or, it's rare off the top that you're able to say to someone, we'll take your case. But, the process is long, it takes years. The letters that we send back to inmates say we're a very small organization, we have limited funding, and we're able to take a very limited number of cases.
And is it the same, I'm sorry.
And, well, you know, the organizations in the network come in all sizes and all fiscal, with all kinds of fiscal abilities. So if it's a case where I think, like the Innocence Project in New York, that's certainly better funded, might be able to engage, then I can refer that case, or I can go to another state, or like in Christine's case from Indiana, she ended up with the Northwestern Wrongful Conviction Clinic, and our clinic did her amici brief, but the cost of litigation was something that they could handle, not we could handle. You know, I look forward to the day that Indiana is proud of its compensation statute. Just like I'm very proud to say Indiana has a rule of evidence governing recording confessions. That took a lot of effort, but we didn't get it done through the legislature. We got that done through the courts. And the courts adopted a rule. This has to go through the legislature. And we're going to have to deal with the issues. As been said, one of those issues is, some 7 states, I believe, say that if you take from the compensation statute, you can't pursue your civil litigation, which I agree 100% with John. That's not fair. That's not where we, Indiana, want to be when we get this job done. So if persons write to me, they hear that it takes years for us to even screen your case, that our resources are limited, and then after we do our research is when we go to visit the individuals when we think the cases are ones we will pursue.
Do you guys have any questions? Does anybody have a question for our panelists? I know you have some. You're all sitting there. Raquel?
As far as...
Talk louder.
I'm sorry.
That's okay.
As far as you, Miss Friend? Call me Friend. Okay. Miss Friend, as far as you receiving these letters from possible innocent inmates in prison, what are some improvements that you all can do as far as, the slow process? As you said that, it takes time, you don't have a lot of, individuals that are volunteering to help to get these, possible inmates out of prison. So what are some improvements that your organization can do, to improve that process?
Well, resources. So if I had more money, I could do more cases in some way. I'd like to have a private investigator full time, because these cases are driven by the facts. And when Christine Bunch, they'll all tell you, forensic science costs money. It's not free. And so to get, in Mr. Glenn's case, we used this new DNA technology that Prosecutor Carter was willing to consider, but I got it free. So I didn't have a fund I could pay that scientist. I had to talk him into doing it free. And so it's resources. And if there were additional lawyers, if there were additional investigators, if there were additional funds, and there are not presently. Now there is, in Indiana, I understand Notre Dame may be starting a clinic that works on wrongful conviction cases. Nikki's got her hand in it now, so we try to grow our movement every chance we get, just like this, put your email out there, get involved, be willing to stand up for these issues. And that's what I do. I come to these events, I do what I can to spread the word and recruit, but I have to raise money like everybody else.
And you also are a professor teaching. I mean, you've
I'm
got
on the track.
You've got lots of different hats you're wearing.
Right. You wear schools. Higher education these days is there's a lot of money issues, and so it's just part of what we do. That's not a great answer because it doesn't fulfill me, but it's slow. I know Roosevelt for many years, I would say, but I'm one person. This is so slow, but I won't quit. So.
I would want to say something on that. I've been to the clinic many times to visit Fran, and it blew my mind the first time that I walked into that clinic, because I came from Northwestern and they had a team of lawyers and they had a team of students working on my case, and they had advisory boards that stepped up and put up the first $25,000 for the investigation for my case. And I know my overall case cost somewhere upward $3.5–4 million for the investigators alone. So these cases take years. When they screen somebody, they're looking at, do you have 10 years left on your sentence? Because that's how long it's going to take for us to get to you and possibly get you into court, because there just aren't enough attorneys. There aren't going to be enough students to take over this massive load, because I've seen the letters that come in to Indiana. I've seen the ones that come in at Northwestern. I know about the ones that are going to New York. There are hundreds of thousands, and we don't have enough people fighting to save them. It's not been an issue. We are not looking at these people and saying, this is a human rights issue. We have these people who have been victimized, and we're standing here with our hands shackled the same as they are on the inside, because we don't have enough.
I just want to, if I can jump in, we get used to the way things are, right? One of the ways that things are is that the way that people get out of prison for a long time in the United States, right, is through the work of independent lawyers, reinvestigating cases, etc., families paying, mortgaging houses, etc., and then also innocence organizations that are doing this work. We're all taxpayers. We have a system. One of our choices is to task the system itself with doing some checks on itself. Now, I'm not saying that's a replacement for the external check of a project, but I don't know about you, but my tax dollars, I'm happy there is an internal affairs division in this police department in my city. Now, that might have been 50 years ago a very bizarre notion, that you would task the system with having internally a check on itself. And you've all seen the cop shows and everything. There's a team of people inside most major metropolitan police departments tasked with making sure that they're getting it right, that they're rooting out, quote unquote bad cops, that they're controlling some kind of error. I'm not saying they're all designed well, that they're all doing it right, perfectly, but the concept is a good one. It's where I want my tax dollars, some of them going to that. We could make the same argument about wrongful conviction, because if we had a team of serious, straight down the line, let's get it right folks in certainly the major district attorney's offices around the country, right? So they're so-called conviction integrity units. We have a lot of help in uncovering what is currently not being uncovered because we don't have the resources. Because as you saw, the drawers are full of letters still waiting to be reviewed. And the people who are wrongfully convicted, the people who are innocent in prison, are in some ways lucking out or not based on whether the people on the outside are well resourced or not. And that's not what we should have in our system. We pay a lot of money to have the lights on in the courtroom, to pay for the copy machine. We cover a lot of things. One of the basic pieces should be an internal check, not as a replacement for, but as an addition to a vigorous, aggressive effort from the outside to uncover wrongful conviction. And that's something you can, not once we're done with compensation, that's something that is something that you can be a part of as well, because we need a movement that says, hey, this is our system, we're serious about it, and one hallmark of a serious system is that it's concerned about its own errors, and it makes some efforts to root them out and correct them.
We're almost ready for lunch, I think. So here's how this is going to work. The panelists, we're going to go downstairs and we're going to grab a table, And if you guys want to use the restroom, whatever, just stretch your legs for a few minutes, that'd be great. And then if you would follow these, raise your hands, these three young ladies in the front, and they will direct you to where we're all going to have lunch. But before we go to lunch, I do want to recognize Mr. Waters for being here today. Thank you so much. Mr. Waters is, he runs a radio station and runs the film, the TV, I don't even know what you guys call it anymore, at Chesterton High School, but the media, he's a media person at Chesterton High School, and I called him and asked him if he would be willing to videotape this, and thank you to your students. I know you're excited to get out of class today. So thank you all for being here. It really is, it really means a lot to me, so thank you. And they are going to post a YouTube video, which you'll all be able to see. I'll find out whenever it's ready. But just so you understand, the second half of this event, when we return from lunch, the panelists will be speaking. There's ongoing litigation. We will not be recording for YouTube. And again, I'm sure Dean Carey's going to remind you all again, but I will remind you again. Please do not record these three folks as they share their courageous stories with all of us. They don't have to be here. They're here as a favor. And Fran said it very well. They have to relive their ordeal every time they come to speak to us. So I would appreciate the courtesy of respect and not videotaping them. One more thing, I know Roosevelt has Mr. Glenn brought a few copies of his book. I got mine. So if anybody, Christine, did you bring your book? Did you bring? No, I know you did. I don't know if Christine did. Okay. So they have, well, somebody wrote a book about Christine, and we'll let you guys share that. But Roosevelt, I think you have, Lorraine, where are you? About 8 books left. So if you want a copy of the book and you want it autographed, Lorraine, can you wave? She's got the copies. They're $12, and Mr. Glenn has kindly agreed to autograph them for you. So if you want them, there's only a handful here today. Otherwise, I'm sure you can buy Christine's. I bought mine on Amazon, I think, her book, which I still haven't had autographed. I should have brought it. Shoot. Okay, so we're going to now break and...